Well, hi, everybody. Thank you so much for joining us today. And if we don't have a lot of people here, I think we have the right people here. So we'll just look at it that way. I'm really pleased to be here and to have a chance to talk with all of you today about protecting the record for appeal. And most of you, or many of you, know me. I chair the appellate practice at Hanson, Bridgett. I chair the appellate section of the Contra Costa County Bar Association. And I also run a pro bono appellate clinic at UC Hastings called the Hastings Appellate Project. But all that aside, I'm particularly thrilled to have with us today my co-speaker, Tiffany Gates. Tiffany is one of those rare appellate practitioners who not only handles civil appeals, but also handles criminal appeals. And she handles lots of both kinds. And she's very good at criminal appeals and very good at civil appeals. Tiffany has her own solo practice. We used to work together until she got tired of working with somebody less competent and went out on her own. And she's doing really well. And I'm particularly pleased to have her here today to talk about things that I know almost nothing about, which is criminal appeals and issues unique to protecting the record. So welcome, Tiffany, and welcome everybody, and we'll get started. And the first topic we're going to talk about today is Evidence Code Section 766 with respect to moving to strike testimony or requesting a curing instruction. And Evidence Code Section 766 says a witness must give responsive answers to questions, and answers that are not responsive shall be stricken on motion of any party. And so I think, as with many things that we're going to talk about today, first of all, Tiffany and I are always amazed at all the plates that trial lawyers keep in the air in real time. And we come along like Monday morning quarterbacks, and we second guess everything that happened. Looks like my screen's getting a little dark here. But at any rate, we get to second guess things, and we do it after the fact. All of you are making these decisions in real time, and we really respect that. So one of the things you have to decide is, do you object and do you move to strike? And the problem is, if you don't, that issue is forfeited for purposes of appeal. And it's something really that's a judgment call, because the moment you object and move to strike, you're actually focusing the jury on the testimony they just heard, and they're going to think about it some more. But that's okay, because what we're talking about here is preserving this issue for appeal. And if you don't do it, and the case ends up turning on that testimony that shouldn't have come in, you've lost the right to challenge that by not objecting and not moving to strike. And one of the cases is that we cited, Pineda, is very illustrative of that. I'll just touch on it very briefly. But there, one expert had already testified, and another expert for the same party was in the middle of testifying. And it suddenly dawned on counsel that both of these experts had been relying on a lot and talking a lot about these out-of-court statements by witnesses. And belatedly, counsel raised an objection and asked for a voir dire of the current expert that was still testifying on his reliance on these witness statements, which now counsel wanted to challenge. But what he never did was move to strike that testimony or any of the testimony of the expert who had already testified. And so when it went up on appeal, the Court of Appeal ruled that this was a classic example of if you want to object, you've not only got to object timely, but you've also got to move to strike the testimony, and that didn't happen. And so while there was at least a colorable issue of that evidence being improper, the court said it didn't have to really decide that because of the forfeiture. So these are all real-time decisions that all of you are making, but the beauty of making sure to move to strike is that in the right case, where that testimony might end up being the only testimony, or the critical inference might have arisen from that testimony, if you've preserved the issue by moving to strike, then when it goes up on appeal, and of course you've lost, you've appealed, everything's working against you, the Court of Appeal will not be able to say, oh, look at this evidence, this supports the verdict, and therefore you lose. It won't be able to do that because you said that this testimony shouldn't come in. You moved to strike the testimony, and now the Court of Appeal will look at it and say, that's right, that was inadmissible. That's off the table for purposes of our substantial evidence review. So it's not always easy to do this in real time. We really respect that these decisions are made in real time. But I think it's very important for purpose of protecting the record for appeal to make these objections and to move to strike. The second part, move to strike. Yes, the jury is going to think about it again. We never know if they're going to disregard that evidence or not when they go back to the jury room. But we're talking about protecting the record for appeal. Tiffany, anything you want to add?
Great, yeah. Unless there are any questions about that, I'm going to tackle the next subject, which is being sure to obtain a final ruling on a motion in limine to exclude evidence. This obviously is an issue that comes up in both civil and criminal cases. And the relevant code section is Evidence Code Section 353, which states that a verdict or finding shall not be set aside, nor shall the judgment or decision based thereon be reversed by reason of the erroneous admission of evidence unless A, there appears of record an objection to or a motion to exclude or to strike the evidence that was timely made and so stated as to make clear the specific ground of the objection or motion, and B, the court which passes upon the effect of the error or errors is of the opinion that the admitted evidence should have been excluded on the grounds stated, and that the error or errors complained of resulted in a miscarriage of justice. So what does all this mean? Well, basically, if you're pre-trial and you know that there's a particular amount of evidence or a particular group of evidence that you're trying to keep out, obviously the appropriate procedure in that situation is to prepare a motion in limine. And what you want to do is identify the specific legal ground for exclusion. You need to identify with particularity the body of evidence that you don't want admitted. And you need to be sure to make the motion in a time when the judge can actually determine the admissibility of the evidence in the appropriate context. So usually that's pre-trial, but as we all know, judges love to defer ruling, especially when it comes to the exclusion or admission of evidence, oftentimes because they want to see how trial unfolds a little bit before they make a final determination about what can or can't come in. Or sometimes it's because the body of evidence is hard to identify with enough particularity. So for a variety of reasons, judges will sometimes defer ruling on a motion in limine. And when that happens, it's really important for purposes of protecting the appellate record that when the evidence is actually about to be admitted, that the motion in limine be renewed, or rather the motion to exclude be renewed at that moment. I've certainly dealt with cases in the criminal context where an attorney moved to exclude evidence pre-trial, the trial court deferred ruling, and then when the prosecutor went to present the evidence, there was no objection. And so in that situation, unfortunately, the argument that the evidence should never have been admitted was forfeited by counsel's failure to renew the objection at the moment that the evidence was actually presented. So really ensuring that you've secured a final ruling from the trial court is incredibly important for purposes of preserving the appellate record.
And I would just add that in People versus Morris, the court states that defendant made the motion, but he did not, quote, press for a ruling, unquote. And I was, parsing the cases for an understanding of what exactly pressing for a ruling means and when you've satisfied it. And it's not at all clear, but what is clear in Morris is that other than making the motion, it seems like the defendant just rested on the fact that it was made and didn't try to follow up. I also looked at cases and it seems like as long as you've made some attempt on the record to get a ruling on your motion, what the courts are doing is they're treating it as a denied motion when it comes up on appeal. In other words, it could be impossible for you to actually get the court to rule. As we all know, they often just say, well, I'm going to wait till later in the case and see how the evidence develops. And then the evidence develops differently, or the big moment actually never comes sometimes. Sometimes it does, and it's taken up then. But apparently, as long as you try to make a record of getting a ruling before the trial starts, you have pressed for a ruling. And if no ruling is made, and as long as it doesn't get wiped out or rendered, beside the point by what actually happens later in the trial, the Court of Appeal will treat that motion as having been denied. And then it will address the issues. Are you right? Should that evidence have been excluded and whatnot? So I wouldn't fret about what exactly pressing for a ruling means. Just make sure that you get on the record that you want a ruling before the trial starts, and you'll probably have a couple opportunities over the course of right before the trial kicks off, and again right before the other side's case in chief kicks off, to again ask for a ruling and make a record of that.
And Gary, before we move on to the next topic, there is a question in the chat that I think we could address now, which is, could we comment on the case law regarding the waiver of this requirement if such an objection would be futile? So yeah, that's futility is the sort of one of the exceptions to the forfeiture rule. So in this situation, in the case I'm thinking of it, and that I've dealt with, where the trial attorney didn't press for a ruling once the evidence actually was being presented. In that situation, I made a futility argument, and I basically pointed to all the judges' sort of negative comments and reactions to the motion in limine during the pretrial hearing. And then from there, I was able to argue that, had trial counsel pressed for the ruling during trial, it would have been denied anyways. And ultimately, the Court of Appeal agreed. So futility is definitely one way to sort of retrospectively save a failure to press for a ruling in the moment that the evidence is actually being presented. But of course, best practices would be to try to not rely on that exception and just try to press for that ruling if you can.
And I would say, I see there's another comment there, but I would just say before we take a look at that, take a look at People versus Hill. It's 17 Cal 4th 800, People versus Hill, 17 Cal 4th 800. And in that case, it's a classic case. It's a classic case where basically the judge is not only overruling counsel's objections, but also belittling counsel in doing so. And what's interesting there is counsel is pointing out essentially, oh, this is an area that you already ruled that we're not supposed to get into. And the other area, that area is permissible. And the judge has actually mixed it up and got it backwards. So the judge is not only wrong, but he's getting exasperated and giving counsel essentially a beat down in front of the jury, overruling his objections repeatedly, and then making some comments, derisive comments or derisive faces about counsel being the one who's mixed up on this, and get your act together, counsel, and all of this. And in that case, the court says, given that, given what was going on as reflected in the transcript, that was an example of where it would have been futile to object more. Now, that's kind of an extreme case, and you'll know it when it's happening to you. And yes, that's also could be evidence of bias. But I think Tiffany's point is very valid. Be careful about assuming that you've reached the point of futility. I know you don't want the judge sort of, directing anger at you when you're trying to make your case in front of a jury. You're sensitive, and so you're gonna maybe stop objecting if you've been pushed back on a couple times. But don't assume futility is a threshold that's easily reached.
Great.
I think we can go forward.
Sounds good. I think that addressed, hopefully that addressed the second follow-up question we received. Great, it looks like it did. So moving on to the next topic, which is failing to include every ground, including federal constitutional grounds in criminal cases for an objection. So basically here, again, at least in the context of criminal cases, the California Supreme Court has up until recently taken a pretty hard line that if you want to be able to raise any sort of evidentiary argument on appeal, then an objection needed to have been made below, and two, the grounds for the objection needed to have been stated to the trial court. It needs to be the same grounds that you're raising on appeal. So, for example, if trial counsel argued that something should be excluded under Evidence Code Section 352, you might have trouble convincing the Court of Appeal to consider a hearsay objection to that evidence on appeal. So the idea is that you want the grounds to match. So what does that mean for trial practitioners? Well, unfortunately, it means you need to raise every conceivable ground for objection in the trial court, which sounds ridiculous. I'm sure we've all seen transcripts of like depositions, for example, where the attorney just rattles off like 20 objections, none of which really seem to have merit. And certainly none of us want to look like that in court. But nevertheless, since we are here focused on how to preserve the record for appeal, that is in fact the requirement. You need to raise every ground for an objection in the trial court in order to preserve each of those grounds for appellate review later. And again, in the context of criminal cases, that includes not only state law grounds, but any potential federal constitutional grounds. So in the handout, I just want to call out a link that we provided to a great handout from the First District Appellate Project, which is the group of attorneys I work with on my criminal appeals. And they have a great chart that helps you cross-refer between state law objections and then what the equivalent federal constitutional objection would be. So honestly, if you can have a copy of that handy at counsel table, that might just be a good way to make sure that you hit every ground for objection when you need to.
Tiffany, are you seeing in the transcripts that you review that in actual trial, the attorneys are objecting, in one sentence, laying out a series of grounds, or are they, say, making the first objection, and if the judge says sustained, they stop, but if the judge says overruled, then they immediately make another one and sort of work their way through the list? And is there a better practice, do you think, or
I've seen it done both ways. Again, fortunately in trial, it's usually limited to like 2 or 3 grounds for objection. The most common ones I see would be relevance, hearsay, or those are really the 2 biggest ones. There is a slight problem sometimes I run into, which is when the attorney will say both grounds in one breath, and then the court will say, sustained or overruled, but not identify which of the grounds it's ruling on. So there it gets a little tricky. I haven't ever had the Court of Appeal refuse to consider an argument when that happened. If I was, if I was only picking up on one of the grounds for an appellate issue. But it is a little, it gets a little murky when that happens. Yeah, Gary, I don't know, what do you see typically in your transcripts?
I think you more often see what you just referred to, which is objection, relevance, hearsay, and then sustained, and then everybody moves on. Yeah. And I think if you're the party making the objection, you get to say that, hey, I raised both objections and they were both sustained. If you're the party who's trying to overcome, you've got to overcome both on appeal in order to get past that hurdle there. If in fact that testimony was so important to your case that now you're making an issue of it on appeal. I just want to add a little anecdote, which is personal to me, but I think I was maybe 3 years out of law school and a very small matter, had a bench trial, and my firm was crazy enough to send me down there to do this bench trial. The bench trial was going to last a day or a day and a half. And so when it was my turn, I started objecting to everything, and I objected 2 or 3 times, and the judge overruled my objections 2 or 3 times. And then on the next one, when I heard something that I thought I should object to, I said, objection, foundation, authentication. And the judge rolled his eyes and said, overruled, and then with a very sarcastic look on his face said, how about relevance? And I said, yeah, relevance. And he said, sustained. And we kept going. I really stopped objecting after that because it wasn't going well. And his facial contortions were telling me that maybe I better ease up on the objections. And in my mind, I was protecting the record for appeal. in his mind, I was absolutely botching up trial objections. But there you go. You got to start somewhere.
Right.
So I think we're going to go to the offer of proof now. And to me, this is something that ought to be fairly straightforward and fairly simple. And I think where parties get hung up, it's just the pressure of trial, or perhaps it's lawyers with less experience, something like that. But generally speaking, when you run into a roadblock, when your testimony's being challenged, and the judge is saying it's not going to come in, or it's just abstaining, there's a one-word objection, hearsay, and you're surprised it's not going to come in. And now you want to make an offer of proof. Now you want to explain a little bit and get past this objection. And the key really are the three words: substance, purpose, and relevance. Substance, purpose, and relevance. I often see in transcripts when this does get fouled up, I see purpose being addressed. Your Honor, I will show, and then it's the element or the key issue. It's the ultimate proof. I am going to show that actually this witness said the opposite on the prior occasion. Something that's the purpose of what I'm trying to get into. But what I often see is that the offer of proof fails on the relevance and the substance. So in what should be something that's fairly simple, the ability to have a sidebar, to report your offer of proof, to explain the relevance, explain the substance, and ultimately the purpose, and get past that hurdle. If it fails because counsel fails to really treat these as three separate elements. So I look at it as purpose should go to what your evidence is ultimately going to establish. Is it going to establish a key issue in the case? Is it going to establish an element in the case? Is it going to impeach the other witness on one of those things? That's obvious, right? That's the purpose. I'm trying to get this in for the ultimate purpose. Relevance is how what you're going to get into relates to proving that point. How is what you're going to get into going to establish that purpose? That also should not be conceptually hard. And then where it gets a little tricky is in substance, the who, the what, the how of the actual testimony. And you have to say, Your Honor, the witness has this experience, has this, was there at this place, observed this personally, has personal knowledge of the following, will testify that. And you have to really get into that testimony. It's why these things happen outside the presence of the jury. But I want to give you an example of really what is sort of a classic botched up offer of proof. One of the cases in your outline, and we really hope the outline will be a reference after today that you might go back to on occasion, depending on what you're looking for, because there's way more material in there than we could ever cover in an hour. But in one of the cases, which is Semch versus Henry Mayo, Newhall Memorial Hospital, counsel encounters a roadblock. The other side's objecting. The judge is saying the testimony is not going to come in. And the offer of proof is this, and I'm going to read it. The offer is, I will make an offer of proof at this time. Okay, so I'm going to stop there. I will make an offer of proof at this time. So far, he said nothing, right? Just make the offer of proof, right? Get to the substance, the purpose, the relevance, right? And here's what he says. He says, I will make an offer of proof at this time that I will expect to prove, still hasn't said anything, maybe he's getting to purpose now, that I will expect to prove, if not through the testimony of this witness, through the testimony of the same person whose evaluations were just read, that she was fired for diverting drugs from the supply room. So maybe we've heard purpose here. I am going to establish that the plaintiff was actually fired for diverting drugs. We've heard purpose. We've heard nothing about relevance. We've heard nothing about substance. And that was the offer of proof. And the attorney making the offer of proof did one other thing, referred to Defense Exhibit 16. which was apparently this voluminous personnel record file for the plaintiff, her employment history, and it was voluminous. She'd worked there a long time, so just naturally, it was a big file. So somewhere in this file was some evidence that was somehow going to establish the real reason for plaintiff's termination. That's not an offer of proof, and I'm sure all of you can do better. And the key is just remembering to sort of talk about the evidence, talk about which specific evidence you need to get in, talk about why it's admissible, and ultimately talk about why it proves the point that you're trying to prove. Take your time and walk through purpose, relevance, and substance, and you won't have an appellate court tell you later on that you didn't preserve the issue for appeal or that you outright failed to make a proper offer of proof.
Gary, have you found when you review transcripts that courts are generally willing to entertain a 402 hearing on these issues, or how much of a showing do people typically get to make in your experience?
Yeah, I see these more often as sidebars than a pure 402 hearing. There was a time about 10 or 15 years ago where it was all the rage to have 402 hearings about experts before trial. And even then, trial courts were resistant to having 402 hearings, because if you're going to have these full-blown hearings and cross and redirect of the experts outside the presence of the jury before trial, you're almost having another trial before trial. So there's always been resistance to 402 hearings. Maybe they're truncated 402 hearings before trial on key issues. But where I really see the offer of proof issue come up the most in the transcripts that I review in civil appeals is just when the trial is going on and then unexpectedly counsel hits a roadblock and can't get to this testimony. One of the recurring themes of everything we're going to talk about today is that a lot of this really should and does get shaken out before trial. Whether it's the motions in limine, whether it's expert issues and 402 hearings, even if it's just wrangling over stipulations as to certain testimony and whatnot, a lot of these issues, these risks of not preserving them for appeal, can be taken care of before trial starts through the motion practice and in limine motions, all of these things. But it doesn't always. And sometimes there are these moments in trial where you need to make an offer of proof. You need to go through it. You need to go through it step by step. And it's really not that hard. If you really aren't futzing around, if you know what this testimony is that you need to make this part of your case, and you should, you can then walk through purpose, relevance, and substance, and you've made a record. You've made a record. Have the reporter there at sidebar. If the judge won't do it, get that on the record at your first opportunity the next time the jury's out of the room. But you're going to be okay with offers of proof. And yet from time to time, I see an absolute failure of an offer of proof because counsel speaks in the most generalized terms, knowing in his or her mind, hey, I have the evidence, but not explaining to the judge what the evidence is.
Yeah.
I think we're going to move to unreported conferences, which is really, this is really something that should never happen. It should never happen. I mean, those of you who are doing trials on your own have a lot to watch and a lot to worry about. And even then you tend to get your sidebars on the record and so on. But if you have civil trials and you have second chairs or you have co-counsel from other firms at these sort of bet the farm trials, there's no excuse for not getting everything you need to get on the record, getting everything reported. Even if, as I have seen and even experienced when I was doing trials early in my career, even if it's at the next break, during the next break when the jury's out of the room, even if it's the next morning and you're pressing to put something on the record, it's always better to do it sooner than later. We're all living in an age right now where some courts have no reporter and you have to arrange for a reporter. And I urge any of you, especially civil practitioners on this call, if you're going to go up on appeal and there's no transcript, and you're really, even for something that was going to be 4 hours long, or a 1-day bench trial, or a 2-day arbitration. I have an appeal right now that was a short arbitration, and we have no transcript. And it's because the counsel and the client, who are now our client and our co-counsel now, didn't think that the cost involved of the reporter, which was shockingly low compared to what they're facing now that the arbitration went sideways, wasn't economical. It didn't make sense. So they thought they'd just do it and create a record, but no transcript. And that's causing me all kinds of grief right now on appeal. And it is a rare case where you don't have a reporter. It's true. But there are plenty of cases where something doesn't get put on the record when there is a reporter. And we're about to talk about another example of that in our next segment on electronic recordings and other things. But I would just say, be diligent about sidebars getting on the record in real time. And if not in real time, if the reporter won't come over, then during the next break or during the next morning, and things like that. And really, this is something that should never happen. It can be a killer when it does happen. And we see it every now and then, and I'm grappling with it right now.
Are you having to use a settled statement in that appeal?
No, we are not. We're just going by the evidence that was submitted, and we have a lot of legal issues and whatnot. And the other side is so obstreperous that we would never get any kind of agreement as to what was said in the courtroom and not said in the courtroom. So we have an uphill battle, which you always do as appellants, but we're a little bit handcuffed here by the lack of a transcript. Even though this was a so-called short arbitration, and our client and our counsel didn't think at the time that a transcript was economical, and now they're appellants facing a huge judgment. Yeah. And you got to wonder. Yeah. But hindsight is everything on appeal.
Right. we always have the benefit of hindsight. Yeah. So actually, one last question before we move on from that. Gary, are you have you ever seen someone use like a new trial motion after an adverse verdict to try to fill gaps in the record? So, for example, if in a civil case the parties decided not to have jury selection transcribed, but now suddenly there's a bunch of juror misconduct issues. Do you see that happening a lot, where new trial motions are being used to sort of fill those gaps?
Well, it's absolutely bread and butter to use a new trial motion to try to reframe the issues, sharpen the issues, direct the court's attention. And really what you're doing there is you're not really expecting the trial judge to reverse himself and grant the new trial motion, but you're sort of cleaning up the record to date on the arguments you made, how you framed them, how polished they were. That's an opportunity right there to sort of make sure some exhibits get focused on and so on. Going back and having a transcript added that or to try to get a settled statement or something for a new trial motion, I think I haven't seen that. I haven't had to do that or try that. But certainly new trial motions are a key moment where if arguments haven't quite been fleshed out the way you wish they had been, if moments in the trial where you were standing there and everyone was looking at you and you maybe didn't make the perfect offer of proof or didn't make the most articulate argument in that moment, new trial motions are frequently used. I urge people to use them to get the court focused there, because remember, the judge has been there the whole time. And if he grants the new trial motion, you've really hit a home run there, and you've cleaned up your case before it went up on appeal. But yeah, I think they're used to sort of tune up things for appeal, and I see that a lot. And I actually do that a lot if I'm brought in a case to sort of provide some guidance or some backup as the trial goes along. I often recommend doing that. I'm often involved in that.
Great. So the next topic is electronic recordings, which obviously come with some inherent issues when it comes to preserving the record. So in civil cases, I think the most common form of evidence that this typically comes up with is videotape depositions, or just any deposition transcripts that are being used to impeach a witness, for example. And then in criminal cases, where I see this come up the most is with police interviews. So basically, the rule of court is that if you are going to play any sort of audio or video recording in the courtroom, you can lodge a copy of the transcript with the court that has the relevant pages and testimony marked. And then I believe that the transcript gets, like the jurors get copies of the transcript when the audio or video is being played, but then they have to give those copies back. So the transcripts themselves don't actually become evidence; they just become sort of lodged court exhibits. And then just like any other testimony, if the jurors want to hear it again while they're deliberating, then I believe the reporter would just go back into the deliberation room and read them the parts that were played in court. So really the most important thing anytime there's any sort of electronic recording being played is you should either talk to the court and opposing counsel ahead of time and make sure you're clear on whether the reporter is going to be taking it down or not. That's often just the simplest solution, is just have the reporter transcribe it live as if it were some live witness testifying, or alternatively use this transcript lodging procedure and make sure that there are enough copies for the jurors to look at and to follow along, since not everyone is an auditory learner. Yeah, Gary, anything to add?
Well, I want to go back for a moment, if I can. I just wanted to mention that you had asked me about the new trial motion and how that is used sometimes to sort of repackage things. And I think that this is probably true even before the new trial motion, during a trial, during particularly trials that are going to last more than a couple of days, civil trials. The pocket brief on an issue is something that's really important for preserving issues on appeal. Whether we're talking about an offer of proof, you make a very articulate offer of proof, it's on the record, and yes, it's preserved for appeal. You've done it orally, you've done what you can in the moment. And nevertheless, a judge has said, no, you're not going to have the witness get into that. And now you're sort of going back to the counsel table, trying to recalculate, oh, what am I going to do now? And you're muddling through basically for the next little while, and then you hit your rhythm, and you're doing what else you can do, unless it's just an absolute trial stopper, that ruling. And then if trial's continuing, you have an opportunity to make an even better record, which is the pocket brief. Especially in cases where you have someone back at the office, typically it's an associate preparing these things. And in that case, you're having that offer of proof actually made into a brief. Offer of proof, you're walking through the purpose, the substance, the relevance, and you're attaching the exhibits that you have, whether it was prior deposition testimony, whatever it is, the other exhibits that went into that offer of proof, and you're making a written record of it. And you're showing up the next morning, as often is the case, and you're filing it, and if the clerk won't file it, file, it's lodged. And if it's filed or it's lodged, it's in the record on appeal. And now you have really made your best case, even before a motion for new trial, even before going up on appeal. Yes, you've preserved the issue if you've done it artfully, orally, earlier in the day or the prior day. But now you're going in the morning and you've got a pocket brief, and this could be on an offer of proof. It could be on the refusal to rule on a motion in limine. It could be on any of these things. And it's a lot to ask for someone who's doing trials by themselves. But some of the civil practitioners often have another attorney with them at trial or a paralegal with them at trial, and they have support back in the office. And these are ways to really augment the record for the appeal. These are ways to really preserve the record for the appeal. And so I just want to stop here and reiterate, don't overlook the importance of the pocket brief when you're not so busy scrambling with all the other things you got to do to get ready for the next day. try to protect the record for appeal by use of augmenting the record through the pocket brief on these key rulings that have gone against you, and so on. And that's something really important I think we should have talked about.
Definitely. I'm glad you brought that up. And it looks like we have a question regarding transcripts. Do you need to lodge the transcript excerpts if you've already lodged certified deposition transcripts of the witness, and it's a bench trial where you don't need juror copies? I believe the answer is no, you don't have to lodge like a second copy, but it's really important to still state on the record the page and lines of the excerpts that are being read into the record. So that way, even if there's no reporter taking it down, it's still super clear exactly what part of that deposition testimony is being entered into evidence, if that makes sense.
Yeah, no, I think that's critical because at minimum then, when it's months later or more than a year later and the Court of Appeals going through the record, and the key issue is the transcripts that were read into evidence for cross or for impeachment or for whatever, or the witness was, out of state and all you have is the deposition transcript. It's really critical that the Court of Appeal is going to see exactly what was read and where and what it relates to. And if the reporter isn't taking it down, all you've got is this sort of, you've got a note in the transcript, right? And all it says, the reporter puts in brackets, deposition transcript being read. So you as counsel, if that's what's going to happen, if whether it's you're showing some electronic recording, whatever it is, if the reporter is going to stop, then you as counsel have to, it's easy with a deposition, you got page and line numbers. It's very difficult with electronic recordings, depending on what they are. Yeah. So you want to talk about the gist of it if you can. You want to talk about what's going to be played. And maybe if it's an electronic recording, you want to identify the key testimony is going to start at this many minutes and seconds in, and we're going to play it to this many minutes and seconds. You've got some identifiers there for the Court of Appeal, because I'll tell you what, while it's correct to sort of get a thumb drive in as part of the record on appeal, here are the electronic videos or recordings or things that were part of the trial. The Court of Appeal is not going to want to hit play and watch the whole thing if only part of that was played in the courtroom and if it's longer than a couple minutes. They're not going to do it. So it's up to you as counsel. If the reporter's not taking down contemporaneously what is being seen, what is being said, then you're going to have a gap, and that gap could really hurt you on appeal.
Absolutely.
I think demonstrative aids, these things tend to be, I think of the poster boards. I think of the big poster board graphics and things. Mm-hmm. There's no reason why there can't be, 8.5 by 11 size PDFs of these things that are lodged with the court and that can easily become part of the record on appeal. There's no reason why there should be a giant poster board and not a paper version of it that can't be part of the record. And really the same with any of materials that are maybe the exception is you have, in some cases, you have a model, you have a 3D model. But then again, there's no reason why you can't have a sort of multi-page, maybe it's 3 or 4 pages, showing the model from different angles, different views. So again, the court has something to look at of the model, or maybe you have to have a video of the model on a thumb drive that the other side approved and whatnot. I remember cases involving maybe like a 4 foot by 4 foot 3D and about 18 inches high model of a building. And that was actually the focus of a lot of testimony in one appeal that I was working on. And there was no 8.5 by 11 schematic of it. There was no photograph of it. There was nothing. There was just conversation about this model. And so all of these things should not be that hard to get in the record. You're not going to be able to send the model to the Court of Appeal. They're not going to let it come in on a table and be wheeled into the Court of Appeal and sit there for 1.5 years. But all of these things ought to be fairly straightforward at getting in. If you think about it ahead of time, if you plan for how Not just you're going to win the trial, because that's the best way to win every appeal, is to win a trial. But if the case goes sideways and you go up on appeal, how are you protected? How is everything that you're going to do and everything that you're going to want the Court of Appeal to hear and to see going to be there in the record for you when you need it? We're going to talk about jury instructions here. We're going to talk about them initially in the form of omissions, failures to do things. I think really, honestly, we could have like a 3-hour seminar on jury instructions, or a 2-hour seminar on jury instructions, and a 3-hour seminar on jury instructions and verdict forms. But we'll do what we can here in the time that we have to talk about these a little bit. I'm not quite as familiar, or not that familiar, with how this plays out in criminal cases, but I'll start out by talking about civil cases. And if you're new to all this, and you start looking at cases and you see these bold declarative statements that the parties are entitled to correct instructions, and you might be thinking, well, thank God I don't have to worry about it. But that's not the case, right? The judge doesn't do this for you. The judge doesn't have to do this for you. And Code of Civil Procedure Section 607A requires you in a civil case to provide the jury instructions, proposed jury instructions, to the judge in a timely fashion. And typically you're going to do it. You're gonna make a record. So you're gonna prepare your proposed jury instructions. They're gonna be in the correct form. You're going to submit them. The other side is going to submit them. And already you're thinking, I'm making a record. These are what I wanted. And these are what the other side has submitted. A lot happens after that, right? And a lot happens really, really quickly. First, the judge typically will say to you guys, I've got your competing jury instructions. A lot of them are the same. Go out tonight after trial and work out which ones you agree on, and come back to me with a joint submission, something to that effect. Let's get as many of these agreed upon as possible. Maybe you're even able to do that before, but you've still made your independent submission to make your record. So now what's happening is you're going over it with counsel, you're agreeing to some, you're not agreeing to others. And now the area of disputed instructions becomes smaller. You've agreed to maybe many of them, and you're able to tell the judge, we're going to go with these. We've agreed to all these, but here's the ones we disagree on. And as long as you're working your way through that, and as long as you're standing your ground as to these are the instructions that I need, you're going to be protected from forfeiture, the failure to request the proper jury instruction. There are some sort of basic points to follow. Keep your proposed instructions simple. Use the approved jury instructions if at all possible. Don't try to create hybrid instructions or write one out of whole cloth, or maybe not even go back to the old book of approved jury instructions. Has been out of fashion for several years and years now. And California, what approved jury instructions, civil and so on, are what everybody uses. Don't go back to that just because you see something there. Stick to the basics. If you have to draft a special instruction, one case citation only, one statute, if it's a statute that's driving this instruction. Keep it as simple as possible, because what you're doing when you're deviating from the approved jury instructions, and you have to in some cases, what you're doing is you're possibly inviting error, because now you're drafting a jury instruction, and if you draft it wrong, you've actually invited the error, and that's going to come back to haunt you on appeal. But right now we're talking about avoiding forfeiture and preserving the record for appeal. So remember to keep it simple, request all the instructions you'll need to establish the elements of your case, your various theories for relief, and submit them in a timely fashion. That's the starting point. After that, everything that happens after that is about avoiding invited error, which we'll get into a little bit further in a couple minutes.
And one thing I just want to add about jury instructions is, I've seen lots of situations where the jury instructions are being finalized kind of in a little bit of a scramble towards the end of trial as the parties are, closing their cases and are, looking to closing argument. And a lot of judges are super great in that they will let you email them stuff directly at night because they understand it's this really dynamic process. But emails don't make it onto the appellate record. So to the extent any of those emails involve, settling the jury instructions, again, just going back to the whole theme of today, which is just please make sure that at some point it gets put on the record, what happened via email the night before, and that the, appropriate finalized version gets some sort of like clerk stamp on it or something so that later we on appeal can tell the Court of Appeal with certainty, this is what the jury received in the deliberation room.
I think that's a fantastic point, and I've actually seen this, and I've seen this play out in a particular way, which I'll describe. It's very late. The case is about to go to the jury. It's a civil case. It's been a 3-week jury trial, and there's wrangling over a couple of jury instructions. And the judge is emailing the lawyers saying, I'm going to use this instruction. I'm not going to use the one submitted by plaintiff. I'm not going to use the one submitted by defendant, but I have come up with this one, and I'm going to use this one. If you want to argue about that, or if you have a better way, email me tonight and let me know your thoughts. And so there's this flurry of emails. And case is going to go to the jury the next day. And opposing counsel emails back, I'm fine with that instruction. I'm fine with that instruction, Your Honor. So right there, if it turns out, as it did in this case, that instruction was flawed, that party that just emailed back and said, I'm fine with that instruction, invited the error. Yes, it didn't draft the instruction. Yes, it tried to submit and did submit an alternative instruction, but that party submitted agreement in email with that proposed instruction, which was a hybrid drafted by the court. That's not in the record. That's not in the record unless you print out those emails that morning before you go to court. You print out those emails, you slap a pleading on there, you make them an exhibit, and you authenticate them in declaration style. And you say that these are the emails that the court sent to the parties and the parties sent to the court the night before. And you go in and you have it filed as an exhibit. And even if the clerk pushes back or the court pushes back and it won't file it, it's lodged. You give it to the clerk, it's lodged. Anything that's filed, anything that's lodged is part of the record now. Now, maybe we'll get this in later on appeal if that didn't happen. Maybe we'll move to augment the record and maybe we'll get it in, but the other side's going to resist, right? Because it's really the smoking gun against them now. They're going to resist. But what we're talking about here really is maximizing as trial is happening for the appeal later. And to me, this is just a tremendous example of a thing that sort of exists more and more these days. It's outside the record. It could be really important. And it would be a very simple thing just to print them out, create a pleading, plaintiff's exhibit of ex parte communications between court and parties, read jury instructions, and lay out the typical authentication and things you'd state in a declaration, sign it, and go into court with it the next morning. And now it's part of the record. Now, when you designate the clerk's transcript or you want to include it in an appellant's appendix, it's in. And you don't have to wrangle, you don't have to move, you don't have to lament, you don't have to struggle. So maybe I'm talking about making my life easier as appellate counsel, but I'm also talking about making your life easier as appellant. And this is a very, very important issue. And I'm glad you brought it up, Tiffany. If you have a moment, Tiffany, are there any particular criminal case, jury instruction, cases or topics here in our outline that you could just briefly highlight?
Sure. Well, I'll just,
you know.
say generally to you criminal practitioners out there in attendance that obviously the, obligation on you is slightly different in criminal cases because for the most part, trial judges have a lot of sua sponte instructional obligations. So the kind of stressful selection of jury instructions that Gary was just describing for civil practitioners, fortunately doesn't apply to you for the most part. But the biggest place where I kind of, as a criminal appellate practitioner, where I bump into issues is when an attorney wanted a clarifying instruction or alternatively a pinpoint instruction, which is sort of where you call out a more particular category of evidence, or you highlight a more specific legal concept that isn't really covered by the approved jury instructions. Their courts are pretty hard-lined that if you didn't ask for it, you can't argue about it on appeal. So if ever there's a moment where you're confronted with a jury instruction that's technically correct, but it's maybe missing some information, the onus is going to be on you to seek that clarifying language from the court, notwithstanding their sort of sua sponte instructional obligations. So again, clarifying instructions and pinpoint instructions are really where I would urge the criminal practitioners in the group to really spend some time either before trial or as you're approaching the end of trial and you're starting to think towards jury instructions, really focus some energy there, because otherwise the failure to request those will result in your client forfeiting the issue for appeal.
And I see a question from one of the audience about motions and making the record more clear when judges deny a motion without really clearly stating the reasons why. Yeah. And I think the same logic will apply whether it's motion practice before trial, whether that's summary judgment and what have you, or whether the question is talking about motions in limine. Either way, really the moving the motion, the opposition, any reply, the exhibits attached, all of that is your record. And for questions of law, it really doesn't matter what the judge's reasoning was. If it's denied and it goes up on appeal and it's a question of law, the Court of Appeal is just going to take it up on the merit and rule on it irrespective of the judge's reasoning. It's a little more problematic in the motion in limine sense because you have this whole drama of having the motion denied and now you've got to deal with it during the trial. And you got to renew your objection, and you got to fight those sidebars. You got to do those things again, and you got to be careful not to forget to do those things. But again, if the motion has been properly written, focused, clear, it really doesn't matter that the judge was not very clear in grounds for denial. And I think the best answer to this question is make sure that your motions are clear, concise, easy to follow, and you'll take some comfort in that, even if you've got this sort of wishy-washy or mishmash order denying your motion. The Court of Appeal will be able to go with you and not go with the reasoning of the court because it's going to review it independently anyway.
And from my personal experience, I've certainly, second chaired trials, or at least argued the motions in limine for a trial where the judge just got sick of kind of arguing with everyone and then just said, that's it, motion denied, and then refused to explain the reasoning. So when we took that up on appeal, the strategy was just, well, let's just point to what the judge, asked during the hearing and what kind of reasoning does that reveal. So there's always a way around it if the judge doesn't kind of definitively state, I'm denying this motion because. You can usually infer the reasoning from what was said at the hearing oftentimes. And then like Gary said, the parties' arguments typically frame the issues as well. So if you are in a situation where it's not a de novo review, and you are in fact kind of looking at, did the court abuse its discretion? Typically speaking, I think you're safe on appeal, so long as you got the judge to do a little bit of talking at the hearing. So yeah, I mean, I suppose there's a situation where the judge might just offer no reasoning whatsoever and just say denied, but I've certainly never seen that happen. So hopefully it doesn't happen to you.
Tiffany, we're gonna start squeezing on time here, but
Yeah.
could you talk about, attorney and prosecutorial misconduct a little bit? I think that's an important one.
Yeah, absolutely. And I can
get
do it quickly too, because the test is the same for civil and criminal cases. So that's nice and easy. Basically, in either context, if the opposing attorney, whether it's a prosecutor or plaintiff's attorney in a civil case or defense attorney in a civil case, does something improper in their argument, or even in their questioning of witnesses, misconduct can occur at any time during a trial, then what you want to do as the trial attorney is object. And this is important, ask for an admonition. That is the most typical reason I see that courts of appeal will refuse to consider a claim of any sort of attorney misconduct, is if no admonition was requested. Now, we do have sort of an exception for futility in this scenario as well. But like we talked about when it comes to the exclusion of evidence, that is not an exception that you want to be resting on. It is hard to prove, and I've never succeeded in convincing a court of that it would have been futile to request an admonition when it comes to attorney misconduct. So the key is not just objecting, but asking for that admonition, which again is awful from the trial attorney's perspective, because then you're just drawing attention to the bad behavior. And it kind of creates this weird circus-like atmosphere sometimes in the courtroom where one attorney is just blatantly violating rules, and the judge can only kind of chastise them a little bit in front of the jury. So it is certainly from the trial attorney's perspective, probably the least desirable thing that you have to do. But from the perspective of preserving the record for appeal, that request for an admonition is typically, fatal. If someone fails to do it, that's fatal to the claim.
And actually, I just wanted to add that over the years, I've seen cases where attorney misconduct in closing arguments is occurring, and it's blatant, it's frequent, and there's not even an objection, never mind a request for an admonition when it first starts happening. And it goes on and it goes on and it goes on, and you finish the transcript and you're just mystified. Why didn't counsel object? And I actually, got to talk to the trial attorneys in a couple of those instances. And they had this belief in this sort of cardinal rule that one never objects during closing argument. And they let that cardinal rule stand in the way. They wanted to object, they were going to object, but you don't object to the other side's closing argument. And I haven't seen that happen in a while. I hope that people are smarter than that, because if it's attorney misconduct, it. It kind of makes your skin crawl when you hear it. And when you hear it the second time, you should be objecting and asking for an admonition. In this case, it happened throughout the closing argument, and it would have been a fantastic basis for reversal. But not only was there no request for an admonition, there was no objection. And the reason was, counsel never, you never object during closing argument. Hey, if it's attorney misconduct, object and make a record. Object once, request an admonition once, and you've preserved the issue for appeal. How about sentencing? Can we get sentencing in?
Yeah, sure.
We're going to run out of time, but
yeah. So sentencing is sort of from a criminal law perspective, obviously, is sort of the reverse of jury instructions. Whereas most jury instruction issues are automatically preserved because trial courts just have this sua sponte obligation. With sentencing, it's the opposite. Almost none of the sentencing issues you might want to raise on appeal are preserved without an objection. So I've listed something like eight examples of things that need to be objected to if we want to be able to raise the argument on appeal. Really, the only very narrow exception to this requirement of objecting to any sort of sentencing error is if ultimately the sentence was just flat out unauthorized, meaning under no legal theory could it have ever been imposed. Like basically the court had no discretion to impose a particular sentence. But in my 10 plus years of doing criminal appeals, I've never once actually come across a truly unauthorized sentence. I'm sure it happens, but my point is it's not an exception that we should be relying on because it's just not very, very typical. So when you're at sentencing, hopefully by then you've reviewed the probation report, you've submitted your own sentencing brief, and so you're going to be really kind of keyed up on the issues. But so the most important thing is to sort of listen to the court's tentative ruling and really be sure to kind of pick apart, like, what are the biggest issues that you see with respect to what the court is planning to do. If it's probation, make sure you look at the conditions, make sure that they all, seem suitable for what happened in this case. There's been a lot of litigation around the In re Ricardo P decision that basically kind of reinvigorates the Lent test for the need for a kind of nexus between the probation condition and the crime of conviction, and then also the potential for future criminality. So definitely always kind of have that in mind if probation's on the table. If the court's potentially using dual use of facts, you want to be on the lookout for that as well. Yeah, I mean, so again, just that list I provided is sort of the most common examples I could come up with based on my own experience, and I'm sure all you criminal practitioners out there see those on a pretty regular basis. So just be sure to object, because this is one place where courts will find forfeiture.
And also, Tiffany, maybe I'm off on a tangent here, but something you just said a moment ago reminded me of the whole crimmigration issue.
Oh, right.
Is there anything you could quickly say about criminal counsel being aware of immigration consequences and how that failure to be aware of them could be harmful?
Sure. Yeah. Well, there's been a lot of good law actually coming out for the criminal defense bar about this. Doesn't so much come up during sentencing as it does during a guilty plea hearing. Okay. So if you're advising your client about the potential consequences of a guilty plea, just be sure to be aware of potential immigration consequences. Always just kind of have it in the back of your mind. Obviously, for some clients, it's just a non-issue if they're citizens or permanent residents or something. But to the extent it might become an issue, just be sure that that's on your radar kind of early on. And my understanding too is, now I'm wishing I'd reread this case right before this seminar, but I think that trial judges also now have a certain obligation when it comes to advising criminal defendants with respect to immigration consequences. So it's not just a counsel issue; it's a trial judge issue as well. But again, best practices, and certainly for the sake of being the most zealous advocate you can be for your client, make sure that you are aware of those consequences. Don't just count on the court to.
We have one final question, and maybe we can grapple with it a little bit, and then we'll stop here because we're past time. There are other material in the handout about verdict forms and whatnot. I'll just quickly say, with respect to verdict forms, you have the forfeiture issue, you have the invited error issue, and it's always sort of a struggle. What's the right level of interrogatories in the verdict form? If you could somehow know you were going to win ahead of time, you want the simplest one, like liable and damages, and just fill in yes and the amount. But if you're going to lose, you want it to be more than that, so you can sort of parse it out, right? So it's a struggle. It's very difficult, but watch out for forfeiture and invited error. And take a look at the materials. If you have things that you'd like to ask us after this seminar is over, shoot us an email. We'll try to help you if we can. The last question is, what about the fact that misconduct isn't realized until afterwards, such as a lie that only comes to light later? In a civil case, I suppose you, within certain time restraints, you have, motion for new trial, motion to vacate the judgment, things of that nature. But I think a lot of times, we either never know about that kind of misconduct, or we find out about it later. And in a civil context, it's too late later. If it's 6 months after the trial and we find out the witness was lying about everything. And that's why we have discovery. That's why we've got to take the depositions. That's why we have to probe. That's why we do the fact gathering. But yeah, that can be a real issue. And in the end of the day, witnesses can lie, if that's what this question is referring to. I'm not so sure what the criminal aspects or contexts are. And Tiffany, maybe you could just briefly answer that if you have any thoughts. Sure. And I'll thank everyone in advance for attending today. Yeah, I think from the criminal law perspective, it would be the same procedural
like you would want to move for a new trial. And the great news in criminal cases is your time frame for moving for a new trial is much longer than it is in civil cases. Because in civil cases, you only have like 10 days from when judgment is entered, which typically happens very shortly after the verdict is rendered. Whereas in criminal cases, judgment isn't entered until sentencing occurs. And there's typically a pretty long drag between verdict and sentencing. So that gives you plenty of time to move for a new trial based on attorney misconduct. Or I think it's called, in the new trial statute, I think it's called like irregularity in the proceedings of counsel or something weird like that. But basically it means attorney misconduct. So there's definitely recourse if that happens. Yeah.
So I think what you've just seen is the reason why Tiffany's here at this seminar today. And for all of you criminal practitioners, Tiffany is very approachable, a fabulous person to consult with, even if it's just a quick phone call to pick her brain. So feel free to do that. I'm always around, and most of you know where to find me. I'm always happy to chat. And I just want to thank all of you for joining us today. And I hope we've been helpful. We can't hear you, Anne.
Anne, I think you're on mute still.
Again, thank you. Thank you. I'm going to turn this off.